In the last class, we talked about the tort. Tort is basically a civil wrong, and then we talk about the negligency. That if one party is negligent and because of that other party suffers some injury, then he will be held liable for the tortious action, and he should compensate the innocent party. Now, an act of negligence can make other parties suffer. Similarly, a negligent misstatement, giving someone false, misleading advice, misleading advices, it is also known as a tortious action. So basically, if someone does a negligent act, and if someone make a negligent or false or misleading statement, he will he can also be held liable under the tortious act. Okay, so a party can suffer loss by relying on incorrect advice or false misleading statement. If one party is negligent, then the other party can suffer loss. Similarly, if one party gives incorrect advice and other party, by relying on that incorrect advice, does take an action, and because of that he suffer losses, then the innocent party can also put up claim to the other party, okay, on the other party under the tort law. Okay, in order for an action of negligent misstatement to be successful, there must be a special relationship between both parties. It's not like that if anyone in a general context give you an advice, and because of that advice you suffer the loss, you can put a claim on the other person. No, if you want to be successful in an action for negligent misstatement, you have to prove that there was a special relationship between two parties. There was a special relationship. Now, what does the special relationship means? It exists where a professional person advise a known person who relies on statement for a known purpose. Special relationship means that one party, as a professional, give an advice to other party knowing that the other party will rely on my statement for this specific purpose. For this specific purpose, then we will say that there was a special relationship. And under this context, if the special relationship arises and the other party suffer losses, then you can put up a claim for negligent mistake. Okay, so special relationship need to be existed between two parties. So it's not like that, if you go to a dinner or if you go to a function, your friend give you an advice and you rely on that advice and make decision and you got the loss, you cannot put up the claim on friend. Why? Because there was no special relationship. However, if your friend was a professional person, let's say he was a professional accountant, he was a professional auditor, or he was any professional person, and he was giving you the advice, knowing that for this purpose you want advice, and knowing that you will rely on his advice and do this stuff to take this action, then there will be a special relationship. Okay, but generally, it's not like that. If anyone give you a wrong advice, then you can put up a claim on tort, a claim of tort negligent misstatement on that person. Okay, so special relationship exists where a professional person advise you advises a known person. It means both parties know each other, relies on statement for known purpose. No, you and the other party know that on my advice he will rely on my advice and will do or will take this specific action. Okay, liability will only arise where defendant is in business of giving professional advice and statement is given in that context. So I have told you about this, that when when the innocent party or the claimant will prove that the other party defendant, he was giving professional advice and in the professional context, okay, basically, then the liability will arise. Otherwise, generally the liability does not arise. Okay, now auditors of a company owe duty of care company only, i.e. shareholders. It is very, very, very important point. An auditor who is responsible for preparing an audit report, the auditor only owe duty of care to company. Company means the shareholders, the current shareholders, the existing shareholders of the company. What does this mean? That let's say if an auditor report was false, if an auditor report was misleading, deceptive, then only shareholder can put up the claim against an auditor. Existing shareholders can put up a claim against auditors. Okay, that because of your incorrect audit report, because of your misleading audit report, we suffered these losses, we suffered dividend losses or any kind of losses. Okay, then the current shareholders can put up a claim on auditors. So auditors of a company only owe duty of care to existing shareholders. Auditors don't owe duty of care to general public and shareholders that are planning to increase shareholdings, which means potential investors. A very, very, very important point. Look, if I am a current shareholder of a company, okay, then auditor owe duty of care to me. If I am going to purchase more shares on the company, and for purchasing the more shares on the company, I relied on the auditor's report, and let's say the auditor report was false, then in that case, auditor don't owe duty of care to me. Auditor don't owe duty of care to me in that case. If I am planning to increase my shareholding, or if person any general public person, any public person from public, he wants to purchase a share in a company, then the auditors don't owe duty of care to him or her. Very important point. This point was established, or this point was derived with a very famous case, Caparo Industries versus Dickman and others, in where there was an auditor who prepared an audit report, and in that audit report, the company, he showed company that the company has a bright prospect. The company was basically overvalued. So Dickman, so Caparo Industries, basically Dickman was auditor, and Caparo Industries were ones, who were going to purchase the shares of the company. So what happened was, there was an auditor and there was a potential investor who was going to invest in the company, who was going to purchase a share in the company. The auditor prepared an audit report, and in audit report, he showed the company as a bright prospect. Basically, he mentioned, or he showed the valuation of the company more. So company was basically overvalued. Now, Caparo Industries, when they saw the audit report and they see that, oh, the company valuation is really good, and the company valuation is really good, company has bright prospect, so they purchased the shares in the company. And afterwards, they found out that, the auditor had overvalued the company, and they have purchased share expensive. The company was not that much, the company did not have that much bright prospect. So they put up a claim of the investment on the auditor who prepared that audit report. In that case, from that case onwards, it was derived that auditor, basically what happened was that that audit report, it was prepared basically for the current shareholders, and it was mentioned only that it was mentioned in the audit report as well, that it is for the current shareholders. It is not for the, suppliers, it is not for the customers, it is not for the banks, it is not for the shareholders who want to invest more in the company. It's not for them, it was for the current shareholders. So basically what happened was that, the auditor was saved. They didn't owe duty of care to Caparo Industries, who purchased the shares in the company relying on the audit report. The auditors owe duty of care only to the existing shareholders of the company. Even let's say if there was a shareholder in the company, and while he saw the audit report, and he, planned to increase or purchase more shares in the company, for that reason, auditors are don't owe duty of care to him as well. So, only the current existing shareholders, it means, the auditors audit report, the shareholders appoint auditors, right, to audit the financial statement prepared by the management of the company. So basically, for that reason only, the auditor can be held liable. Okay. But for any other reason, auditors are not liable to the general public, or to the potential investors, or to the current shareholders who are planning to invest more in the company. Okay. Accountants owe duty of care to the clients and to all those whom he know will rely on accounts. In case of accountants, accountant owes duty of care to all those people who they know that, obviously, first of all, they will owe the duty of care to their clients, right? And to all those whom they know will rely on accounts. If the accountant knows that this person can rely on my account while making this decision, then accountants owe duty of care to that person only. Pure economic loss with respect to negligent misstatement is recoverable. A very, very important point. In case of negligent act and other parties suffered a physical injury, the pure economic loss was not recoverable. Consequential economic loss was recoverable. But in case of negligent misstatement, pure economic loss is also recoverable. Now, what does this mean? Like, for example, if someone give you a wrong advice, and based on that wrong advice, you made any business decision, and you suffered, let's say, loss of profits because of that advice, you got into losses, plus your reputation was also affected, plus your goodwill was also affected. You can put up the claim for the loss of goodwill and reputation as well, in addition to what actually you got lost, and what actually, you suffered loss because of that negligent misstatement. So you can recover both. So it means, in case of the negligent misstatement, any loss, any loss can be recoverable. Either it is a consequential economic loss or is it a pure economic loss. This was not a case in the Negligence Act. Okay. If auditor is auditing accounts of the subsidiary company, then he owe duty of care to both parent and subsidiary company. So let's say there's a group in which there are parent company as well, in which there are subsidiary company as well. The auditors owe duty of care to both the parent company and subsidiary company. Okay, the auditors of the parent company owe the duty of care to both the parent company and subsidiary company as well. Now, what are the remedies of negligence? What are the solutions? So remedy, uh, now let's see. Principal remedy is the damages, and damages caused to the claimant must be of type that is reasonably foreseeable. So the principal remedy, the common law remedy of the negligence are the damages. Damages means monetary compensation to innocent party. Cost to the claimant must be of type that is reasonably foreseeable. So it means the damages should be reasonably foreseeable. It is the job of claimant to prove that defendant was in breach of the duty of care. So claimant will have to prove that the other party, that is defendant, he was in breach of duty of care or he was negligent. Okay. Only those damages will be awarded that are not too remote. Only those damages will be awarded that are not too remote. In case of basically the negligent misstatement, every loss is recoverable. Okay, every loss is basically recoverable. But for other, only those damages will be awarded that are not too remote. Not too remote are what losses that arise from direct consequence of the negligence that were reasonably foreseeable or were in your contemplation. So if let's say if I did some tortious act and because of that other party suffer some damages, other party suffer some losses, then I have to claim the damages which arises because of the direct consequence of my action or my negligence, okay, or my breach of the duty of care, or any loss that I could foresee, that was in my mind that if I will be negligent, then the other party can suffer this loss as well. That was in my contemplation, back of my mind. I knew that, it could, this loss could also arise. That loss is also not too remote, and you have to pay the damages for that as well. Okay. Defenses in negligence. Now, in those defendant, what defenses he can put up in the case of negligence to save himself. Okay. Now, what are the defenses? Defendant will have to prove that he was not negligent. Defendant will have to prove that he was not negligent. This will not happen if, in these three situations, it will be difficult for the negligent party or the defendant to prove that, he was not negligent. First one, harm would not have normally happened if the proper care was taken. If the proper care was taken, if the standard of care was there, then harm would not have happened, right? So if the defendant basically didn't took proper care, so other parties suffered the harm, then in that case, the defend it will be difficult to for the defendant to prove that he was not negligent, right? So he have to compensate the innocent party. Okay. Second one is recepsa loquitur. Now, what does this mean? Mere occurrence of some type of accident is sufficient to imply negligence. Mere occurrence of some type of accident is sufficient to imply negligence. Like the thing which happens, it speaks for itself. The action itself says that who is responsible. Like, for example, there was a doctor who was a surgeon who was doing a surgery, and during the surgery, let's say he forgot some medical equipment in the body of the patient. Now, this act itself implies that doctor was negligent, right? Then in that case, he cannot present any defense, right? Because the act itself implies that he was negligent. Claimant have to prove nothing. The defendant cannot save himself, cannot put up any defense, right? The act itself speaks for itself. And the third one is defendant was in control of situation and victim wasn't. If the defendant was in control of situation and victim was not, then it will be difficult for defendant to prove that he was not negligent, right? So in these three cases, it will be difficult for defendant to prove that he was not negligent. Now, what are the defenses that he can put up? What are the valid defenses? So there are, we are going to talk about four things: contributory negligence, voluntary non-fit injuria, novus actus intervenens, and exclusion clause. Now let's start with the contributory negligence. If the victim himself was responsible for his own injury, then defendant can plead for contributory negligence. Court may then reduce the damages depending upon scenario. It is only a partial defense. So contributory negligence is a partial defense. In the contributory negligence, if you can prove that other party was also responsible for his further damages as well, then you could be safe. Like, for example, there's a case in your book in which there was a lady. Uh, she was using uh, a public toilet, and because of faulty door lock, she got stuck inside the toilet. Now she did what? There now there was no door handle. It was broken. She could not get out of the bathroom. So he did what? The toilet paper roller, that is usually of plastic or maybe steel. He she put the step on that roller to get out of the to get out of the washroom, and unfortunately she slipped and she suffered many damages. She suffered damages. Now what happened was that she sued, obviously, the district council, the local council. And when the case was brought forward to the court said that yes, the door lock was faulty, and that you know this is because of the negligence of the council. They didn't overlook or monitor the washroom situations or the bathroom public toilet situations, so they are liable for that thing. They are not liable for your additional injury because because you stepped on that toilet roller holder. They are not responsible for that. You contributed to your injury yourself. You should knew that the roller is, it's usually of the plastic and steel. Even it is, if it is of steel, there's 60-70 kg, it will be difficult to put the leg and get out, right? She must knew that it will be difficult. She can fail, and she can have severe injuries. So this is what court said, that they will pay you the defense, they will pay you the compensation, but you are yourself responsible for the additional injury, and you will not get the compensation for that. So in that case, the lady, she claimed the amount she claimed, she only got 25% of that. Okay, so contributory negligence is just a partial defense. uh, Voluntary non-fit injuria. If victim himself has given consent for loss, then it exempts defendant to show duty of care. Consent can be expressed or implied from claimant's conduct. If the victim, it's himself, give a consent that, if something happens to me, you are not liable, I will be liable personally, then the other party is not liable. Like for example, in a boxing match, you give a consent, right? You give a consent that, if something happens, even if I die, then the organizers, they are not responsible, so they are giving consent, right? So this is voluntary non-fit injuria, that if other party gives a consent that, if anything happens to me, you are not responsible, then you are not responsible. Simple. Okay. Next is novus actus interveniens. Now, novus actus interveniens. Now, what does this word mean? It means an act that is intervening, and breaking the chain of causation. An act that is intervening and it is breaking the chain of causation. Now, what does this mean? Like, for example, you suffered a minor, let's say minor fever or minor flu. You go to a doctor, and the doctor gave you some medicines, and because of that, your flu become more severe. Then, you visit another doctor, and other doctor gave you an injection, and because of that, your condition becomes, worse, very worse, serious. Now, the first doctor who gave you the medicines, and because of that your condition got severe, he will be, he's liable, right? He's negligent, he's liable for that. But when an intervening act came, the other doctor gave you an injection which make your condition much worse, then the first doctor will not be liable for that extra severe condition of yours. Why? Because the intervening act, there was an act by you which has break the chain of causation. Chain of causation means that if one thing has caused the other, and there's something, something comes in between, then that breaks the chain of causation. Then the extra liability will be removed from the original person. Okay. When there is a new intervening act, it breaks the chain of causation, removing liability from defendant. These are unforeseen events that breaks link between defendant's tort and eventual harm. So defendant's tort, a civil wrong, plus the ultimate end damages. If something intervenes and cause, the extra damages, then the original person, the person who did the original tort, he will be not liable for that extra portion. Okay. Now, what are three types of intervening act? The first one is act of claimant. If due to act of claimant loss is increased, then defendant is not responsible for that increased loss. Okay. So I gave you one example. I can give another example. Like for example, you were working in a factory and you got slipped, and because you got slipped, you suffered some, you suffered some minor injury in your leg. Okay. You suffered some minor injury on your leg, and you could not walk properly. You suffered minor injuries, and when you suffer minor injury, then when you were going home, instead of using the chairlift, instead of using lift, you try to walk onto the stairs fast. You try to walk on the stairs, or you got down to the ground floor using the stairs. And when you were using the stairs, because already you had minor damage, you could not walk properly. You fell off, and eventually let's say your leg got fractured. Now, the factory floor was slippery. Who was responsible? The employer, right? He could have taken the standard of care, sufficient standard of care. So because of his negligence, you suffer minor injury. But because of your own act of of walking down the stairs, while you could have used the lift, and you knew that you have suffered some injury, it will be difficult for you to walk off by stairs. You should have used the lift, right? But you didn't. So you contributed, basically. Because of you, your loss got increased. So an intervening act by you break the chain of causation, and link between the original tort and eventual harm got break. So the original tort, or the employer, will not be responsible for all of your eventual harm. Okay. So he is not liable for your act, basically. Act of third party. If due to an act which was unforeseeable of third party, the loss is increased, defendant is not responsible for that increased loss. Like, for example, defendant committed tort, and some third party also intervene, and your damage got increased because of that third party. Then the original person or the defendant will not be liable for that extra loss. Okay. There's a case in your book in which the local council, they negligently struck a water pipe outside the house of a claimant. Now, when the water pipe was struck, all of the pipelines inside the house exploded. And when they were exploded, the house was, you could not live in that house, right? This because it caused extensive damage, and pipeline got burst, and house has to be vacated. Now, what happened was that when house got vacated, squatters, basically, the persons who unlawfully break into the house, like robbers, the drug addicts, when they see that this place is empty for a long time, they enter that, right? So similarly, the squatters entered, and they lived there. They break the things, and the loss got increased. Now, when the claimant, they got back after 1 year, and they saw that the condition of the house was severe, so they put up the claim of that extra loss on the council as well. But the council was not liable. Why? Because there was an intervening act that break the link, that break the chain of causation. And because of that act, the eventual harm, the defendant are not responsible for that. They are responsible for the negligence of striking the water pipe outside the house, but they are not liable for the acts of squatters. Okay. Natural events. If due to some natural disaster the loss increased, then defendant is not responsible for that increased loss. Okay. You were on the road, you negligently struck a car of some other person, and other person car suffered some damage. And when he was taking the damaged car to the repair, there was a storm, a very storm, heavy rain, flood, and the car, the damage of the car got increased. Now, you are not responsible, the defendant is not responsible for the claimant's increased loss because of that storm, right? Because of that natural event, he is not responsible. There's a case here in your book in which there was a ship, two ships, they collide, and because of that, the one party was negligent, and two ships collide. And the one the the innocent party ship suffered some losses. So while they were taking the ship for the repair purpose, there was a very heavy storm, and because of that storm, their the original damage got worse. The original damage got worse. Okay. So the defendant, or the innocent party, or the claimant, they cannot recover the compensation for the natural event. Okay. For whatever the damages, for whatever the damage was caused by the weather. Okay. So when an intervening act break the chain of causation, then after that intervening act, the extra damage that you cause, that you get, or the extra loss that you get, defendant is not liable for that. Then comes exclusion clause. If an exclusion clause is found to be valid, this constitutes a viable defense against any action for negligence. We talked about the exclusion clause in the chapter 2 in detail. So if there was a valid exclusion clause, it passed the common law test, statutory test, and it was valid. So you can use that exclusion clause to remove yourself from the liability. and it can be used as a viable defense against any action for the negligence, right? And you can put up an exclusion clause in which you can mention that for this thing I am not liable, right? So if that exclusion clause is valid, it passes the test, then it is a defense for you, you can use in case of negligence. The last thing is tort of passing off. Tort of passing off means basically where one business uses similar name to existing business. When one business uses similar name to existing business, it misleads public into believing that they are similar. It causes or can cause actual damage to existing business. Now there are three things that need to arise if you want to be successful in the tort of passing off case. Okay, tort of passing off means that, let's say there's a new company, it uses a name, a company uses a name that is similar to some other company. A company uses a name that is similar to some other kind of company. Like for example, one company name is Buttercup Dairy Company, other company name is Buttercup Margarine Company. Now in both companies there's a word buttercup used, right? If one business use similar name to existing business or similar kind of name to the existing business, and because of that the public get confused, they believe that they both are similar, and due to this the public deals, instead of dealing with the existing business, they are moving towards the original business or the new business, believing that they are linked to the existing business, and the existing business suffer damages, actual damages. Then in that case tort of passing off arise, and the new business will be prevent to use the similar kind of name. Okay, this tort protects goodwill, reputation, and the profit of the business. This tort is created to protect the goodwill, reputation, and the profit of the business. Okay, so three conditions need to be met. You are using a similar kind of name to an existing business, and because of that the general public is confused, they believe that they both are similar, and because of that the original business or the existing business suffer losses. Then that business can put up a claim of tort of passing off on the other business, and the new business can be restrained from trading under that name, and they may have to pay damages as well. Okay, so this is tort of passing off.